So we now switch to the second major institutional exception from Article 1, MFN rule, which is regional integration. Regional economic integration is a phenomenon that all of you are aware of, all of you face, that actually we don't even think of it that much. However, it has greatly influenced the overall scheme of international trade in the course of the last, I guess, 70 years. And the results of those regional integration agreements are really present, especially in European regions, but now all countries in the world are involved in this process. Therefore, regional integration is here to stay, clearly. It greatly impacts business patterns, it greatly impacts investment patterns, and it greatly influences political patterns. So just following the news on any business media, you will necessarily once in 2 days come across some highlights with respect to regional integration moves. So now let's see what are those regional integration options, what are the forms of possible regional integration, what are the WTO rules on those, and why are they, when are they compatible with WTO, so that to be permitted not to comply with the general MFN obligation. As I said, regional integration currently is indeed an extremely hot topic, and one of the first things Donald Trump made as president on this first day in the office was not really the construction of the wall on the border with Mexico, but was the agreement, what was the decision to withdraw the United States from the agreement, which is known as TPP, Trade Trans-Pacific Partnership. It's a huge trade deal, which we will talk about today, and it was one of the major points of his election campaign, that participation in this Trans-Pacific Partnership goes contrary to the interests of the United States. This regional agreement has been criticized by many, even very renowned economists like Paul Krugman. However, we are not really that used to this recent, the trade community is not that used to this recent trends of decline in regional integration moves, withdrawal from agreements. It is a relatively recent phenomenon because from 1940s till very recent years, the number of regional agreements which have been formed was always growing and growing. And there is the graph on the next slide, which clearly demonstrates you the trend with the increase of regional agreements coming into force year by year. Comparing to a very limited number of agreements shortly after the Second World War, you see a great proliferation, increase in number of agreements that comes with time. And the trend is still there, despite all this recent slowdown that we may see. But, well, the reasons for this slowdown are also evident. We will talk about those in a little while. So, why are those things important, and how important are they? We were talking about so-called MFN tariff rates. Those are the rates which are usually applied by governments according to their WTO schedules and according to their choice to apply a rate which should be below the levels prescribed in the schedules. So according to the statistics which has been calculated, about 42% of the global trade is currently traded free, so without the imposition of any tariffs. The rest, 58% of products will be subject to tariffs. They may be relatively small. Majority of products are traded at MFN rates below 10%, whereas about 13 most sensitive, as we call them, products will be subject to higher MFN rates. But still, a huge chunk, about 40% of all products, are traded freely without any restrictions. And we already remember the reasons behind that from our economics discussion, when we were saying there is no much need for protectionism in your economy if there is no domestic producer who would benefit from this support. So the only reason that you could get some more money to the budget because of the tariff is not really compelling, because ultimately your consumers pay. So already the fact that we have these MFN tariffs, which are applied without any discrimination at this low rate, is a big advantage, is a big achievement of the current regulation of tariffs under the WTO rules. However, under the preferential trade agreements, not on MFN basis, not available to everyone, but still under these preferential tariff regimes, 28% of global trade, in addition to those 42, are also subject to zero tariffs. These agreements fully liberalized additional 28% of global trade. That is a lot compared to the moves under the WTO. It's the common accord, the understanding that was shared by all members at the beginning of the Uruguay round, and as a result of the Uruguay round, that all tariffs shall be decreased, and there have been so many tariff rounds which we are aware of. So as a result of these regional trade agreements, additional around 30% are traded freely. Yes, this free trade is not available to all WTO members. It is only available to selected partners within your regional trading blocks or within your regional trading schemes, be those bilateral or multilateral. However, it's a huge influence that these agreements have on international trade patterns. Because once you produce a product in a territory that has a free trade agreement or a customs union with the other product where your major consumer is located, your product could get to that territory at a much more competitive price because it is no longer subject to any customs duties. So now, as you may see, according to MFN tariffs, about 58% is subject to tariff duties. In global arrangements, which in the arrangements we are going to talk about, in regional trade agreements we are going to talk about now, only 5% of imports are subject to tariffs. So imagine how influential it is. So if you make an agreement, you open up your borders, you open up your market to your partner, whereas with respect to the rest of the world, you still maintain certain tariffs. And that is also the reality that we live in, that regional trade agreements are, on the one hand, great in scope and great in coverage, and on the other hand, extremely influential in the decisions, for instance, to select the global value chain or construct your supply patterns and production patterns, because again, you can benefit from free trade. So what is the regional integration ultimately? I keep saying this phrase, not giving you the definition. A regional integration is an economic process by which a group of countries form closer economic links with each other than with third countries or with the rest of the world. So it's a form of establishing stronger economic ties. We understand that in 1940s, when the text of the GATT was discussed, one of the major reasons for this regional integration escape clause was the need for colonies to still keep their preferential relations with metropolitan states so that they could not be subject to these higher MFN tariffs, and they could still keep those stronger economic ties that they had developed over years. However, with development in time, it is far not only these colonial structures that now matters, and you understand there is very little influence. Well, there is some influence, but there is little influence of these colonial ties still in the current trade patterns, and therefore these economic integrations are proliferating. Where could you try locate those agreements? Where could you try find the text of the agreements? Well, as usual, there are many databases internationally which are very helpful in that sense. The World Bank has a beautiful global preferential trade agreements database, and you can download the texts of most agreements they managed to collect. There is a database which was developed by World Trade Institute in Bern. It is called DESTA. They also have something over 1,000 various free trade agreements and customs unions and whatnot. Though, again, they may be greatly overlapping, there is no ultimate clarity with respect to all of those agreements being enforced or not. However, there is also a WTO database available on the WTO website, WTO.org. You can, I think we already talked about that in one of our previous lectures, but you can definitely find a lot of information there on the WTO website. Trade topics section could also lead you to the heading regional integration or regional trade agreements. If you click on it, you will get to their database of regional economic agreements that have been notified to the WTO. So what are the figures there? So in total, currently the WTO database has 303 agreements which were notified. If we take all notifications separately, then it would top up to 481 agreements. However, we should be careful with those figures for several reasons. The major reason is that still many of countries participating in regional integration are not yet WTO members. And they are clearly under no obligation to notify agreements they participate in. Secondly, even some of the current WTO members, for whatever reason, choose not to notify. The penalties for those are next to nothing. So there is no real tool to compel WTO members notify their agreements. Many of them do, some of them don't, and therefore this database is clearly not exhaustive. But it is also very helpful. You may find the text of most of the agreements which you may need in your day-to-day affairs. You may see most of the rules which will apply to your product if you produce a product from one territory and send it to the other territory parties to those agreements. And you will also find information about the agreement being enforced or not, which is very helpful for those of you who are not that profound in determining that on your own, all these legalistic tricks and searching information in international legal databases. Therefore, actually, it is very helpful for those basic users who just want to do some research or understand the current situation, the current state of play in between certain territories. So regional trade agreements are called regional, but frankly, they are not that regional any longer. Many of them are cross-regional. I would mention you agreements on free trade agreement between US and Singapore, a free trade agreement between EU and Canada, which is now being discussed, a free trade agreement, which is there, so it will be in place quite soon. Then a free trade agreement between EU and South Korea. So those countries do not have geographical proximity, but these countries in current times do have trade ties, and these countries do want to benefit from free trade. Mostly, as you may see, regional agreements. So regional agreements is now more a term of art. We keep calling them regional agreements just because that is the old term that has been used. But frankly, they are no longer necessarily regional, and those can be agreements which establish closer ties between very distant territories, but interested in fostering their cooperation in the field of trade. So as you may see from the slide, the majority of the agreements in these integration moves have been formed by the European countries. You may also see that East Asia is very active, and you will see today, I will show you some more examples on how active really the Asian region is. It's booming in sense of trade development, and it really actively participates in most of global or at least mega regional moves, which we will mention today as well. You may also see that former Soviet territories have been quite active, especially that happened in the 1990s after the collapse of the Soviet Union. There was a common understanding there is a need to maintain these closer economic ties between the territories, and therefore a lot of free trade agreements have been formed. It is not only the CIS free trade agreement, which was there in 1994, but actually was not really well functioning, and therefore quite recently the new CIS free trade agreement was adopted. The Eurasian Economic Union is also the example of 5 former Soviet territories which currently are most integrated as compared to, well, within the former Soviet republics, not taking into account the Baltic states, currently part of the European Union. And then there are many other agreements which were formed by former Soviet territories in bilateral fashion, agreements on free trade. So you may see that the Caribbean region is yet lagging behind, but they have big agreements. They are not many in number, but they are quite big in volume. So they have comprehensive agreements which currently cover most of the trade in the Caribbean. So which are the countries that are leaders? Which are the WTO members that are leaders in making regional trade agreements? I just chose very randomly those territories which have the biggest numbers, at least according to the WTO Secretariat information available on the website. And you may see that clearly EU is in the forefront of this integration trend. We would expect maybe the United States to be the second runner-up, but actually it is not. You may see that such territories like Norway or Liechtenstein, clearly because of, again, close connections with the European territories, are jumping to the second place, not to mention Chile, which is very active in the field of economic integration. You may also see that Mexico is quite active. I'm pretty sure you already remember the agreement that Mexico participates in, NAFTA, North American Free Trade Agreement. It's US, Canada, and Mexico, but Mexico has 21 more agreements with other territories. As for Russia, it has notified 11 free trade agreements or customs union agreements, Kazakhstan 10, Ukraine 18, very active, and the association agreement with the EU, which actually caused all these concerns in 2014 and which was the trigger for the complexities in relations between Ukraine and Russia. The association agreement with the EU is actually mostly the agreement on free trade. There are some disciplines on regulatory harmonization. However, the most important part of this, the most effective part, the most controversial part of this agreement from the Russian point of view was the free trade agreement. So as for these territories, you may see that necessarily, well, a lot of agreements would be made by countries which are active in global trade, not necessarily big, and it can be very well cross-regional. You see Singapore, relatively small territory as compared to many others, but extremely active in making free trade agreements so that to open up their market and have easier access to foreign markets. Are there any territories which do not have free trade agreements? In the book by Peter van den Bosch, there is the sentence which has been very commonly used and discussed, and everyone keeps saying that Mongolia was the last WTO member to enter a free trade agreement. So this last bastion fell somewhere in 2002 or 2004, don't remember. However, actually, even with non-WTO members, we should say that the countries that have not notified agreements to the WTO and claim to be out of the regional integration patterns, they are actually in. For whatever reason, just the WTO database does not possess this information currently. So what are those territories which are marked as having zero regional trade agreements? No agreements notified. Djibouti. Djibouti actually is a WTO member, and it does have a customs union. It participates in the customs union called COMESA. It stands for Common Market for Eastern and Southern Africa. It has also signed the African Continental Free Trade Agreement, a number of bilateral agreements, and Djibouti is very interested in fostering regional economic integration, especially with Ethiopia. So despite the information on the WTO website, Djibouti does have a customs union and a number of other agreements, which were just not notified to the WTO by Djibouti. As for Mauritania, Mauritania indeed is not active in regional trade agreements. It is an Islamic republic and it is classified as a lower middle income country. It actually withdrew from the economic community of West African states in 1999, I guess, somewhere in 1999. This agreement is called ECOWAS. And they actually also, they were also party to the Arab Maghreb Union, such a union which actually never came to be operational in practice. And ultimately, despite the ratification of the Pan-Arab Free Trade Area, it also has not taken steps to grant trade preferences under this agreement. Tariff concessions under other bilateral agreements have not been in place. All that was true, but for the fact that very recently Mauritania joined the agreement which is called the African Continental Free Trade Agreement. It is a free trade agreement which actually now is the largest in the world in terms of number of participating countries, and Mauritania is also part of it. Then there is one more WTO member which is, for whatever reason, not listed among those having notified agreements. It's an archipelago called Palau. It's an archipelago of over 500 islands, Western Pacific Ocean, capital Koror Island, and the population is about 18,000 people. So you could think maybe Palau indeed doesn't participate in regional trade agreements. It is not the case. You may see that Palau participates in the ACP-EC agreement, Asian, Caribbean, Pacific Palau has an agreement with the United States. Palau participates in the agreement called Pacific Island Countries Trade Agreement. So it also turns out to be quite active. For those territories which are observers and also mentioned on the WTO website, you may see again that even Somalia, which is in the very difficult situation in sense of governance and in sense of the ability of the government to maintain the powers, Somalia even participates in the African Continent Free Trade Agreement. South Sudan, which is an extremely new state, which just happened to emerge on the global map, is also part of the COMESA agreement. So what is the conclusion I'm heading to? The conclusion is that there is no country in the world currently not involved in these regional integration trends, which necessarily violate Article 1, which give tariff preferences to one country, to the products from one country, and do not extend those tariff preferences to the like product from the other WTO members. However, we understand that for some countries, 1, 2, 3 agreements is the maximum. For some territories that have the capacities and have the powers to do that, it's over 40 agreements currently in place. So one more interesting trend that we were facing before, somewhere maybe 2016, 17, and it was subject to all discussions and all debates in press. It was discussed on WTO Public Forum many times, and it was generally a subject to the common feeling of unity. It is the so-called mega regional blocks. Those are regional trade agreements which were proposed to be concluded among countries that embrace a considerable share of the world trade and that span across sub-regions. There is no exact legal definition of those mega regionals. It's just the term that is mostly used by media and maybe by some of the sociologists. So there is no clear understanding what it is, but here are some of the examples. Well, the most well-known and widely discussed, already mentioned, is TPP, Trans-Pacific Partnership. It's a big agreement that was planned to be a free trade agreement between 12 territories, including Australia, all the ASEAN territories, the so-called ASEAN, the United States also. And that is exactly this agreement that Donald Trump withdrew the US from on the first day in the office. And indeed, the agreement was not only about free trade, it included a whole lot of disciplines with respect to other matters of trade harmonization and trade simplification between the territories. It included a lot of matters that we would call deep integration. We'll talk about that in a little while. And this agreement is currently proposed to remain in force, called as the TPP 11 or TPP 2. It's this agreement with the exclusion of the US. But again, the participation of the US mattered a lot in sense of the reasons in participating there. Other territories do share, many of them do share free trade regimes under their individual bilateral agreements or under the ASEAN regime if we talk of Southeast Asia. And the agreement is ratified by Australia, Canada, Japan, Mexico, New Zealand, and Singapore. So this accord with the absence of the US on board is much less impressive as compared to what it was expected to be. Then the other big agreement, which you may also hear about, is the so-called RCEP. Again, all 8 ASEAN countries, not some of them, but all of the ASEAN countries. It's a free trade agreement in Southeast Asia. And you may see that many of those territories are least developed countries, Laos, Myanmar, for instance. So for them, access to getting access to foreign product markets may be also a big advantage in sense of their development. And in addition to that, Australia, China, that is important. Japan, though China actually has free trade with ASEAN. China, Japan, New Zealand, South Korea. India was also participating in the discussion, but very recently it opted out, fearing imports from China. Negotiations are still ongoing, and you may see discussions regularly on press about this agreement called RCEP, Regional Comprehensive Economic Partnership. And the last but not least is the agreement under the auspices of the agreement called APEC, which you may have heard of, not OPEC about oil, APEC. And they also proposed the free trade area for Asia and Pacific. This is in a very initial stage of discussion. There is a common feeling that such a free trade agreement could be very advantageous. But again, the interests of those territories are very diverse. You see, it includes Russia, it includes the United States, it includes China. So what sort of free trade between those territories could be possible is still unclear, given that US and China are currently in a, well, at least some sort of a trade tension, if not called that war. So opening up the markets under the free trade regime may be extremely problematic. So if we were just to put these territories on a graph, you may see that some of the Asian countries and Australia as well are participating in all of the three accords. Then some other countries join depending on their interest. I'm quite puzzled that the US is, well, clearly it's an old graph of 2014. The US is still within the TPP orbit, so it is no longer there actually, but it is still part of the big APEC free trade agreement, which is the biggest one. And just to compare, again, before all these falling apart started, before the US withdrew, and before other countries started feeling frustration in those global accords, in those mega regional accords, not global, let's not mix it up with the global scale for the WTO. So with those regional or mega regional trends, you may see how much of the world experts would be influenced by just one agreement. You may see that the aggregate share of the world GDP would be really impressive, especially for the APEC agreement if it came to existence. But again, currently, with all the trade tensions that are there in place, it is very questionable whether such agreements will come into existence in the next several years. So I already mentioned this concept of deep integration, and it is something that is really here for the last 20, 30 years. Before we came to this concept of deep integration, mainly free trade areas, customs unions would cover such matters as tariffs and other border measures, and that is it. If you take those bilateral agreements which were concluded by former Soviet territories, now independent countries in 1990s, most of those bilateral agreements are very shallow indeed. They only cover tariffs, very few border measures, and that is it, full stop. Modern generation free trade agreements and customs unions are much more broad in coverage and in scope of those matters, which will be included within the coverage of the provisions of the agreement. So when we talk of agreements, regional agreements of a deep integration model, then we mean that those are agreements that do not only contain rules on tariffs and non-tariff restrictions, which we already know, but Those also regulate the business environment in a more general sense within the borders, when the product already crossed the border, and then it faces checks, taxes, it faces antitrust rules, it faces some other questions which may relate to, I don't know, well, necessities to obtain licensing or obtain permits, authorizations. All these matters are already part of this deep integration. Questions of protection of intellectual property, questions of protecting foreign investment, all that is subject to those modern agreements, which are deep integration type of agreements. And this is interesting because, as I said, those agreements between former Soviet territories, which were bilateral, would perfectly fit 2-3 pages when printed, whereas modern regional trade agreements would take hundreds of pages, literally hundreds of pages, and TPP occupies hundreds of pages, and it includes all sorts of things you would not think of in the context of free trade regime, as the agreement is called, because it covers everything, including anti-corruption practices and um, environmental matters. So what are the possible questions of those deep integration? So you may see some of those are called WTO plus. So those agreements may go even further as compared to the disciplines of the WTO. And there can be even WTO-X areas. So those matters which are not actually covered by WTO rules, but which will still be very positive for the mutual trade. Competition policies, simplification, environmental laws, as I said, specific rules on innovative policies, specific rules on education and training, rules on public administration, nuclear safety. I don't see if it is there or not, apart from money laundering. It can be currency conversion rates and currency arrangements. There can be questions of human rights, illegal immigration, even illicit drugs trafficking, that will be subject to regulation under those agreements. What is really impressive, because those agreements from purely trade agreements become agreements on approximation of legislation and development of, let's call them still, regional rules that influence domestic businesses. What are the reasons behind this huge proliferation of regional trade agreements? They are in a way straightforward, and I guess you could come up with a number of those reasons yourself if you would put this video on pause for a while and think about it. But here are the most clear reasons why regional trade agreements why they have proliferated that greatly. To begin with, making such an agreement gives you a chance to expand your trade, and you can export more. Even despite all this liberal thinking, all countries wish to maximize exports. And expansion of trade is not only getting easier access to exporting your product to a foreign market, but it is also a way to get easier access to components that you may need, get it from the other territory, and then have it transformed in the finished product within your territory with the value added. Efficiency considerations, very similar to what I said. You have easier access to materials, you have easier access to components, and therefore it is just saving you a lot when getting access to those inputs. There is also the feeling that the multilateral trading system, I don't know why I call it scheme here, the multilateral trading system doesn't function that well. There is some feeling that the WTO was not very productive in the course of the last 25 years, and therefore countries feel going bilateral or going in smaller groups is simpler. Also, given the multiplier complexity, the more participants join the WTO table, the more difficult it becomes to reach any agreement. There is also a fear to lose the market share by being excluded from existing regional agreements, You see everyone is doing it and you also wish to do it, so there is the domino effect which clearly is there. Free trade agreements are very good mechanisms to attract foreign direct investment, and countries do indeed use those to attract FDIs. There can ultimately be political and geopolitical considerations. There can be a wish to build confidence, and building confidence is through trade is the most actually stable mechanism, because if it's in your economic interest to cooperate with me, to establish good relations, then politically we will maintain good relations as well. And ultimately, regional trade agreements are relatively easy in sense of access, in sense of administration. Therefore, many countries currently do not feel bothered by entering regional trade agreements in a way that they do not feel their competences, their sovereignty to be significantly oppressed, as long as we talk of free trade areas, should they have economic interest in drawing these agreements. So what are the forms of regional trade agreements? Let's now go to the specific examples and understand what are the possible forms that are there. Free trade areas. Free trade areas are defined in the GATT. There is a definition. Luckily, here we have a clear legal definition as a group of 2 or more customs territories in which the duties or other restrictive regulations of commerce are eliminated on substantially all the trade. So these are territories, separate customs territories, which decide in their mutual trade to get rid of duties and get rid of other restrictive regulations of commerce. Notice the words are eliminated. When we say are eliminated in English, we mean that they have been eliminated for good. So if they are eliminated, they're not going to be restored. So they are already eliminated on substantially all the trade. We will talk about this in more detail down the lecture, but here let's try to make some examples. NAFTA, North American Free Trade Agreement, is a good example of it. So you understand that as between USA, Mexico, and Canada, products are traded freely. There are no duties and no other restrictive regulations of commerce that are applicable. Well, at least there should be no. Then ASEAN, already mentioned, Southeastern Asia, a huge block of countries that trade freely. EU South Korea Free Trade Agreement, which I mentioned, or the agreement between the Eurasian Economic Union and Vietnam, also a big agreement, which, as you see, can be formed not necessarily only with an individual country, but can also be formed with a bloc like EU or Eurasian Economic Union. So once again, to wrap it up, to make sure we understand what a free trade area is, so say EU and South Korea make a free trade agreement. So now from 10% of a customs duty for, I don't know, bicycles, lipsticks, or jeans, from 10%, the customs duty goes to 0. That is important. It will only be 0 for products that will be originating in South Korea or in EU. Any reasonable businessman, imagine you were the businessman from, say, the United States. The United States and the EU do not have a free trade regime. And you may come up to a relatively interesting, tricky idea. Why not send your US product to Korea, for instance, repack it, label it as product of South Korea, and then send it to the EU. So if you will be subject to a 10% duty on MFN basis, you will not be subject to any duty if you send your product from Korea. So there can be a feeling that any reasonable businessman would like to go around the system and make use of this advantage, which is given to one member and not granted immediately and unconditionally to the like product of other members. So in order to avoid that, free trade agreements necessarily insist on confirmation of origin of a product. You see, they still maintain the border between EU and South Korea. And at the border, they can check, the customs official can check what is the origin of the product that is coming to our territory. So the origin of the product will be determined based on certain criteria. And if the customs official is not satisfied, if he does not believe that this product comes really from South Korea, and he feels that it is a product that is just traveling through South Korea in order to avoid paying the customs duty, then he will not give this duty-free treatment to this product. So how do we understand the origin of the product? You remember within the WTO Annex 1A, there is even a separate agreement called Agreement on the Rules of Origin. And that very agreement exactly talks of how to determine origin, though it does not prescribe the rules. It just gives some guidance to domestic legislators to implement their rules. So what are the possible rules of origin? How do you demonstrate that your product indeed comes from the territory that is eligible for zero duty on imports? So that is one of the reasons we have chambers of commerce and industry in most countries. Those chambers of commerce and industry are actually issuing those certificates of origin. So if you need to have it issued, you could go to the Chamber of Commerce and request that to be provided. So that is a service. They charge you a certain amount, but still they then go and verify that you indeed produce this product here. It may be also for some products, it may be easy for customs officials to determine the origin because they may know the technology, they may know what sort of inputs are available in this or that country, and they can easily say that, well, for instance, this type of equipment, this type of process and production methods is not available in, say, well, I don't know, Vietnam, so or Cambodia. So then it is not a product from Cambodia, it is a product from Japan, I don't know. But for some products like agricultural products, apple, cucumber, you can keep looking at it, but you will most often never find out where it was produced. So that is when certificate of origin comes into place. That is when certificate of origin becomes essential. So how do we determine the origin of the product? Because even if we take an example of the iPhone, we should understand that iPhone is produced of 100 different components which added value to the final product. And how do we determine where iPhone originates? So on the one hand, iPhone is assembled in China. Many of the materials for the iPhone are produced in China. However, iPhone was designed in the US, and intellectually it is the product of the US intellectual work. So there is a big value added to the iPhone through this intellectual work, intellectual property. And does it make iPhone a Chinese product or the US product? Or then say if we find out if the semiconductors or whatever those major processor working there, the heart of the phone that connects all the processes together, imagine it is produced in Japan for whatever reason or elsewhere in India. Does it make the iPhone an Indian phone? That is a good question. The answer is we will never know unless we check the specific terms of a free trade agreement. Most modern free trade agreements would have separate chapters which will be called rules of origin. And there you will find out those rules on the determination of origin. What are the possible rules? And rules actually can be different even in one and the same agreement. Depending on the product we talk about, rules may really differ. So the most classical rules are as follows. The rule on substantial transformation of the product. So in order for a product to become a product of this country and benefit from free trade under free trade agreement, there will be a need for substantial transformation. So there will be a requirement that a product undergoes a big change in this territory. It should be a change in the tariff heading or in the tariff subheading. And sometimes you will find in those regional trade agreements opposite a particular type of a product, say an automotive car. Well, automotive car is not a good example. I'll say aluminium in rods. And you will find out how primary aluminium, if it is transformed into a rod, does it make a big difference in sense of the origin? So for instance, in the EU, if we take aluminium foil, aluminium foil that we use in households, it doesn't really matter how you transform aluminium into foil and where you do it. Aluminium foil will always be considered originating in the territory that produced primary aluminium. But for aluminium rods, it's very different under the EU rules. And the EU would consider the aluminium rod to be produced in the territory where this primary aluminium underwent substantial transformation. So those rules are very individual, and each country has individual rules, and each free trade agreement may have individual rules. So we need to check that. So substantial transformation is option 1, value added test option 2. We could say that that country that actually added most value to the product is the origin of it. So, or we could say that a country that added no less than, say, 40% of the value of the iPhone would be considered the country where iPhone originates. And clearly here we calculated based on X works price, deducting all other additional charges that could be charged on the iPhone. But this is very similar to what we discussed in trade remedies. So we need just to see the clean price. Or we could even introduce a list of some manufacturing and processing operations saying that a car can be considered produced in Russia only in case you make welding, stamping, painting in Russia, for instance. That is an option. So countries can decide on their own rules of origin. The rules in the rules of origin agreement just gives them some of the basic advice how that is best approached, and prohibits some of the discriminatory practices that may be played out in this field. So as for the rules of origin, again, we don't know what specific products are subject to which specific rules of origin under free trade agreements. If you would need to find out whether your product shall be treated as produced in Cambodia or not, or as produced in India or not, for the purposes of a free trade agreement, or as produced in South Korea or not, for the purposes of a zero tariff under the free trade agreement between South Korea and EU, then you would need to find out more information on what is the applicable rule of origin with respect to your product. So here, I give you the example of my very random search on the rules of origin facilitator. That's the database that has been developed by the International Trade Center. You see WTO was also participating. And here you may see the video how that actually works. So I'm just typing in a very random, I don't remember, well, I think Kazakhstan, for instance. Yes, why not? And then I select, say, Vietnam to find out whether there is some preferential trade available. And I'm taking just any imaginary product. I'm introducing the code under the HS, railway and tramway passenger coaches. Perfect. Let's find out if there is any preferential rule available. So we see that the database gives us the understanding that, yes, there is in force a free trade agreement between Eurasian Economic Union and Vietnam, and we can qualify for a 0% MFN duty as producers. But what is the rule of origin that will be applicable? You may see it here. There will be even some clarifications coming if you forget what this means. change in heading, CTH, exception to change in heading, tariff classification, regional value content. It is similar to what we discussed, value added content or substantial transformation, the change of heading. So you may see that under these rules as between Kazakhstan and Vietnam, the product will be considered, well, the particular product, this railway carriages, or what was that? So this product will be considered originating in Vietnam or in Kazakhstan if it has undergone substantial transformation or substantial transformation and the value added 50% in the territory. So then if you need more details, actually you can go to the primary legislation, but at least you understand the general approach and you can find more information to give you some very basic assessment. So that was the free trade area. And necessarily we need those rules of origin to avoid free riding, to avoid someone playing around, repacking the product, and seeking the benefits of free trade. What is a customs union? The customs union is the next stage of regional trade liberalization. A customs union is no longer just a free trade area that eliminates tariffs and other restrictive regulations of commerce. A customs union under Article 24.8 is actually a substitution of a single customs territory for two or more customs territories so that the duties and other restrictive regulations of commerce are eliminated with respect to substantially all the trade. So the end of the provision is very similar to what we read with respect to a free trade area, but the customs union is a substitution of a single customs territory for two or more customs territories, and that makes a huge difference as compared to a free trade agreement. So what is a customs union? What are the examples? EU, well, EU will be a little even more advanced, but EU still has a customs union, no doubt. EU-Turkey is a customs union. So you see that there is no need to be an EU member, but it is sufficient to be the party to a EU-Turkey free trade area so that products from Turkey can be introduced to the EU without any duties, and so that the European products could be imported to Turkey without any duties. There is also the oldest customs union internationally. It is SACU, South African Customs Union, Mercosur, that is the customs union, well, intended to be the common market, but actually it's more of a customs union in South America, and the Eurasian Economic Union as well. So there are customs unions also available. Now let's try and understand what a customs union is. So I'm taking just two very random territories because many of those customs unions have many participants. So just to simplify things, if we take country A and B, so there is some border that they maintain, some border checks, and there is some exchange in trade in shares. So very similar to what we had in the previous example, they are trading shares at a 10% duty. So if you send a share from country A to country B, you will have to pay an additional duty of 10%. Now let's imagine these two territories wish to introduce a customs union, and they make an agreement to introduce a customs union. We understood that for these two separate customs territories, a customs union is a substitution of these two territories into one single customs territory. So importantly, what happens is that customs union now takes all those two territories within its ambit, and the customs union does not permit those countries keep their individual customs borders. They do have political borders, no doubt, but as for customs purposes, they have now the common customs territory. And products are traded within these customs unions as freely as between the cities in each of the constituent territories. So when we say a customs union of Eurasian Economic Union, Belarus, Kazakhstan, Kyrgyzstan, Armenia, and Russia, we understand that sending a product from Moscow to St. Petersburg is nearly the same in sense of customs purposes. It's the same as sending this product from Moscow to Minsk or from Moscow to Yerevan. Therefore, this is now one and the common customs territory. There are no longer customs borders. There are no more border checks. As between these two territories, products are traded freely. All duties and other restrictive regulations of commerce are eliminated. Well, with respect to substantially all the trade, there can be some minor exceptions, but mostly when we say of a customs union, that necessarily implies that these territories now have common customs territory. And that makes it very different as compared to the free trade area, because customs unions imply that there are no more borders in between the territories. And that is the reason why I say Russian sanctions, well, counter sanctions are not that effective and have been not that effective at first, because we don't have any borders, say, with Belarus or Kazakhstan in sense of customs. We do have political borders, but we do not have customs borders. And we have one and the same customs territory. We don't have export from Russia to from Belarus to Russia, or from or vice versa, because export implies two different customs territories. So selling a product in Minsk, in Yerevan, or in Moscow makes no difference for the Russian businessman. Well, clearly taking into account all the transportation charges and some other factors that may influence, but still ultimately, from the point of view of customs, it's one and the same territory. And we don't have borders, we don't have border checks within the territory, and products are traded freely. That is how customs unions work. And as I said, that is why we may have oysters from Belarus, for instance, because again, how would you stop this product? You can only try to stop it in shops and try to catch it at the moment it already enters your market, but you cannot really stop it at the border because there is no more customs border. And as for those customs unions, most importantly, the customs unions necessarily have common territory, common customs territory, and common external tariff. Why does it matter? Because if so, products are traded freely within this territory, and then with respect to all foreign products, we should have the common border. Why so? Because if country A maintains a customs duty of 5% and country B maintains a customs duty of 10%, no one will be introducing the product to the territory of this customs union at a customs duty of 10%. Everyone will go through country A, import it there, and then once you're within the union, you can trade it freely. No more customs duties possible. So whenever we talk of a customs union, we always imply they should have common external tariff and common trade policy. And those disadvantages of uncommon trade measures like these Russian counter sanctions exactly show you how bad customs unions are fit for these uncommon policies. Customs unions imply that countries should act jointly now with respect to their trade with the rest of the world, with external trade. So whenever we talk of a customs union, we necessarily expect a common external tariff. That is what we discussed. But apart from the tariff itself, think of, say, anti-dumping measures. If one country applies the anti-dumping measure and the other one does not, then it actually won't work, because the country protecting its market will not manage to protect it, because there is the second market, which is now part of the bigger market of the customs union, that you cannot protect yourself from. You cannot build up the border again, because it won't then be a customs union. So when we talk of customs unions, they do not only imply common tariffs. So it doesn't matter if you import your product to Portugal or to Sweden, customs duties will be the same. Same applies to common external policy, meaning those trade remedies which shall be necessarily applied jointly and simultaneously, otherwise they won't work, meaning that countries can go even further in regulation of their external policies, technical regulations. So those questions that relate to product safety. If one country will be implementing higher rules and the other weaker rules, then higher rules will fail to be implemented. So whenever we talk of free trade area or a customs union, we understand there is a big difference. A free trade area does not apply this commonality of external tariffs and external policies with the other countries, third countries. With a free trade area, you just agree on liberalization of trade with your partner, and that is it. It doesn't influence the rest of the world. You should not align your policies with respect to the rest of the world. However, as for the customs union, you necessarily have to do it. If you don't do it, customs union won't really function. So customs union, as you already understood, imply giving up sovereignty, because now you cannot regulate questions on your tariffs on your own. You have to agree it with your neighbor. You cannot decide on anti-dumping on your own. You have to agree it with your neighbor. You cannot decide on technical regulations. You cannot decide on sanitary rules on your own. You need to agree it with your neighbor. So depending on the neighbor is not always something governments wish. So for instance, the United States is not party to any customs union because they don't want to give up sovereignty. How many customs unions are there as compared to free trade areas? You recall there were around 300 free trade areas in the WTO database. If we check the database and sort it according to the type of the agreement, you may see that there are only 17 notifications on customs unions. And if we deduct EU treaty itself, EU Turkey, EU Andorra, EU San Marino, we will have even 4 less, well, let's say 3 less, 1 remaining as EU treaty. So this is one big market, including Turkey, Andorra, San Marino for the purposes of customs. Again, not for the political purposes. Political borders maintain for the purposes of customs. Political borders remain. So if we deduct these European moves, then it will be 14, right, of customs unions only. Again, because it implies sovereignty losses. And many governments are not ready for that. So then there is one more type of the agreement that we need to discuss. There is one more further step in regional trade liberalization that is possible. It is called common market. Sometimes you can also hear the word single market, the term single market. So what was the idea of a customs union? The idea of a customs union is free movement of goods and services, as you recall, because we now have one and the common territory. And then we have this common external policy with the rest of the world. The common market works a little differently. The common market implies so-called 4 freedoms: free movement of goods, services, capital, and labor. We understand free movement of goods and services. What is free movement of capital and labor? As for labor, we understand that free movement of labor implies easy abilities for work migrants of your trading partner to arrive to your territory and work there. Labor migration, no work permits in the common market. That is exactly what we have, say, in the Eurasian Economic Union. I could travel to Minsk and work there, not needing any work permit. But I could not travel to Brussels and not obtain a work permit and work there as a practicing lawyer, for instance. And then the second, even more tricky element, free movement of capital. What is that? Unrestricted payments and transfers. Immovable property purchase which shall be available to your trading partner, then you will have this free movement of capital. Well, recently, for instance, Ukraine passed a law not permitting Russian citizens to purchase land within the territory of Ukraine. So as long as there is no free movement of capital, clearly we are not thinking of it, but still that will have to be removed if at certain stage Ukraine and Russia may wish to arrive to the common market. Simplification of rules on investment, simplification on the rules of participation in charter capital of companies in the common market. So that is all making this market common, single. It is free movement of these four elements, which are essential. And we should not confuse actually the customs union with the single market. Once again, the customs union is about free movement of goods and services and common external policies. Whereas, let's take the example of Andorra, Monaco, San Marino, and Turkey. They do have a customs union with the EU. They can send products to EU duty-free, and they accept products from Europe duty-free. However, these are not participants in the common market. And you already understand why that happens, especially with respect to Turkey. Labor migration could be a very sensitive issue because, again, ultimately, you want to protect your domestic unemployment rate to remain low. And therefore, those territories are not members to the common market. There is no free movement of capital and labor, but there is all necessary for the customs union: common border and free movement of goods and services. Norway, Iceland, and Liechtenstein are not parties to the EU customs union, interestingly, and you may recall there were historical reasons, and you may recall even that Norway actually withdrew from the EU, just like Britain did recently. So they do form part of the common market, the so-called European Economic Area. So yes, Europeans can travel, EU citizens, EU members, citizens can travel to Norway or Iceland. They would not need the work permit. They cannot be restricted in the right of the land purchase, because they are part of one and the same European Economic Area, which does not actually coincide, completely overlap with the customs union. So not every customs union is necessary, not every common market is necessarily a customs union. The common market is about 4 freedoms. The customs union is about 2 freedoms and a common customs territory. What is important? Because the common customs territory with respect to the rest of the world and aligned policies in sense of customs are more typical of a customs union and not a common market. So why would it matter that much, and why do I spend time on it? Because if you would be following the news, and if you were following the news, you might have actually read about it in more detail. Here is an example of an article of 2016 by The Economist, and they explain the difference between Europe's customs union and single market. Why do they do that? As Britain leaves the European Union, it must decide what economic arrangements it seeks to retain. And here is just a part of this article. When discussing a hard or a soft Brexit, commentators usually talk of the EU's customs union and single market. Currently, Britain is a member of both. So when we really talked for these 2 years of the difference between hard and soft Brexit, what implied is actually whether Britain stays in the economic area, in the common market and whether it stays in the customs union. So what was the ultimate outcome? What was the final decision? You may see there is a press release available on the European Commission website by the European Commission's chief negotiator, talking about points of convergence and divergence following the first round of negotiations with the United Kingdom following Brexit. And here is what this particular press statement says. On the 1st of January 2021, the UK has decided that it will leave the single market, the customs union, and all of our international agreements. Well, that is the hardest Brexit possible. It is the end of the transition period. Come what may, it will no longer be business as usual for the UK or for us. For example, and he gives several examples, customs formalities will be back. There were no customs formalities now, as long as they want to withdraw from the customs union, they will have to introduce customs formalities again. Financial institutions established in the UK will automatically lose the benefit of the financial passport. And this is something which is clearly not a matter of a customs union. It's a matter of the common market. It's one of those 4 liberties, one of those 4 freedoms. And then authorization or certification issued in Britain will no longer enable a product to be placed on the European market, whether it be a vehicle, an industrial good, or even a medical device. So this is again something that we understand as the result of the withdrawal from the customs union, because again, it's common external policy with respect to products entering your territory. So EU is just saying that Britain has chosen the hardest possible way, and they will necessarily withdraw from all those arrangements, though there could be different combinations. They could stay in the single market and leave the customs union, or they could stay in the customs union and leave the single market. But come what may, as the chief negotiator says. And there are other forms of economic integration, just to finish this story. Those are monetary unions, and those clearly, as you understand it from the title, they share a single currency. It's not only Eurozone, and again, you all, I guess, know that Eurozone does not overlap, does not completely correspond to EU membership itself. So euro is only applied by 19 countries out of 27 EU members. But there are other monetary unions that are available internationally. Well, I could mention the Economic and Monetary Community of Central Africa, franc, Eastern Caribbean dollar, Western African Economic and Monetary Unions, franc. So, and there is also a number of de facto monetary unions, which will not even count, say, Switzerland, Liechtenstein, because those currencies are accepted. But let's leave it. Economic and political union market. There is a very unique situation of EU. It's not only economic integration, but it's also political integration, which has been achieved through the creation of common political institutions, like, say, the European Parliament. So that is one of the one and only actual example of economic and political union. And then there are also so-called preferential trade agreements. Those are usually unilateral trade preferences, which can be provided by a WTO member without expecting anything in return. We gave the example of such schemes during our previous lecture. It is GSP, Generalized Scheme of Preferences, and there can be just unilateral trade preferences like the USA African Growth and Opportunity Act, EU trade preferences for countries of the Western Balkans. So again, those are individual preferential arrangements when countries open up their borders to a particular country, territory. And then here we will need to understand also from the perspective of WTO rules whether it could be justified or not. So just a few words about the economics of regional trade agreements. We have the intuition that regional trade agreements should be positive because, again, we talk of the reduction of tariffs, right? However, any regional trade agreement has very dubious effects, and the analysis of this requires some substantial economic knowledge. We are not going to dive in those details now in this particular course. So here, what matters for us is actually to have the feeling what different effects could happen as a result of a regional trade agreement being concluded. So let's take the example of some three countries, country A, B, and C. They are actually trading mainly, let's say, country A and country B are sending some product to country C. Let's imagine those are like products, they have very much in common. Let's say it's identical bicycles which are produced in country A and country B. So my question here is, what will be in this case the situation in sense of prices if country C has a border tariff of 100%. So they introduce the tariff. What would be the price now for the product, say bicycle, from country A if sent to country C? Easy to calculate, right? Same price for bicycle from country B to country C if it's MFN tariff of 100%. It's a high tariff, but let's assume it so just for simplicity purposes. So now in this case, country A, when sending a product to country C, will have to pay $10. Well, the product of country A will now be sold at the price of no less $10 in the market of country C. The product in country B, same product, but which costs more, is now sent to country C at a cost of $16. So imagine that lasts for some time. Clearly, if the two bicycles are identical, no one will be wishing to pay $6 more for bicycles from country B. So ultimately what happens is that bicycle producers in country B sooner or later get bankrupt. They understand they are not competitive as compared to bicycles from country A, and they will choose some other specialization so that country A focuses on bicycles and they focus on something else, in which in a product that according to estimates providing them comparative advantage. So that is all known to us from our economics discussion. As of now, it is relatively simple. We understand that the tariff is bad, but actually doesn't really disturb that much competition as between the two territories, A and B, right? So it only disturbs them jointly in the same fashion. Now let's imagine we are talking of a free trade area or a customs union. Well, let's say free trade area for simplicity purposes, as between countries A and C. So they now get rid of any border restrictions as duties. So duties are now zero, and products and other restrictive regulations of commerce are also eliminated. Say they still maintain border and product is sent from country A to country B. But now this product doesn't pay duties any longer. So what will be the price of this product now in the market of country C? $5, right? So because you don't pay the duty, the price for the product in the market can go down. And because of this agreement, see how dramatic the difference in price between bicycles from B and bicycles from A become. So now if the bicycle consumer wants to choose which bicycle to take, he has much higher incentives to take the bicycle from country A because it is 3 times cheaper. So this is the situation of trade creation. We just get rid of the unnecessary barrier which disturbs us, which we didn't really need. And because of this getting rid of the barrier, we have more trade created because the more efficient producer becomes even more efficient. It becomes most efficient in our market as well. So they will now multiply their production, and then because of the economies of scale, potentially the price for the bicycle could even go below $5. So this is trade creation. This is the positive side of regional trade agreements. It can happen. And then let's compare it to a situation when country B and country C would like to make a regional trade agreement. So country B and country C make the arrangement to get rid of customs duties, right? So the customs duty now also goes to 0. Price for country A product, because there is no free trade between the two territories, is still $10. What is the price for the bicycle from country B? $8, right? So now the situation turns to a completely opposite direction. We see the situation when the less efficient producer becomes artificially more competitive than the original efficient producer. And what would happen in this situation? In this situation, in some time, bicycle producers from country A will start going bankrupt because of the tariff. Their product is not competitive in the foreign market. Because of this tariff, they will have to limit their sales and they will have to potentially go bankrupt. Just because, again, it's only a question of duties applicable against them and not applicable against country B. So that is possible, right? As we said, it can be possible if we talk of regional trade agreements. But here the question is it economically positive or not? And it is not really economically positive because we artificially create demand to a less efficient economic producer. So this effect is called trade diversion. And the understanding of the economic value of a regional trade agreement is not simple and straightforward. Not every free trade agreement is good and positive for the parties, not at all, because that all depends on their product mix, on what sort of products are being traded. Is there much chance of trade creation and trade diversion actually? And it all requires big economic assessment. However, we may already understand that at least it is not that straightforward. We cannot say necessarily that any free trade agreement is good or bad. It requires additional economic analysis. Who was the first to develop this theory with the opposite effects of regional trade agreements, of customs unions? Again, I simplified it as much as possible so that to make it understandable. If you would like to understand more details and consult the original source, Jacob Weiner, an economist, Chicago School, his work of 1950, a very well-known seminal work called The Customs Union Issue. So this is where you could find more information about the economic effects of regional trade agreements. So I've been saying all that so long to finally arrive to the legal text, to finally give you the feeling how that all is possible, how this terrible discrimination is possible, contrary to the principles set forth in Article 1 of the GATT MFN. And here is now time for us to see how this exception is worded. GATT Article 24.5. This is exactly the provision of the exception. Let's read it. Accordingly, the provisions of this agreement shall not prevent, as between the territories of the contracting parties, the formation of a customs union or a free trade area, provided that. Well, I am skipping the words or the adoption of an interim agreement leading to the formation of a free trade area or a customs union, provided that. So let's put aside this interim agreement. We are not now interested in it. So there can be some transitional arrangements. What is most important here, they say the provisions of this agreement, Article 1, shall not prevent the formation of a customs union or a free trade area, provided that we meet certain requirements that will follow. There is one more caveat I wanted to make in this context. Reading this provision, please notice these words, as between the territories of contracting parties. It causes concern. Why so? Because we have the feeling that those customs unions and free trade areas could only be concluded as amongst WTO members. So making an agreement with non-member seems to be contrary to the text. It says, as between the territories of contracting parties is the term that we know. It means parties to the GATT, WTO members. So can agreements with non-members be made? It's a big question. In practice, they are clearly made. But I do also understand the logics behind this provision, this text of the provision. WTO, the GATT, was intended to be the closed club. You only get the benefits if you are within the club. So if you are outside the club, you should have even more willingness to join the club. And that is a provision, if read in this fashion, would greatly restrict the application of any regional agreements beyond the WTO family. However, as I said, in practice, such agreements clearly happen. Belarus is not a WTO member, and it's even the EU, not some other territories that were seeking for this type of interpretation of Article 24.5 that permits agreements with non-members. So we understand that we can be not subject to Article 1, provided that we meet certain requirements. So there are actually two requirements that we will have to comply with so that to be permitted not comply with Article 1. To begin with, it is the so-called external requirement. This external requirement is contained in this definition, which we actually already read in Article 24.5 of the GATT. It says that a free trade area or a customs union, actually both definitions share this same phrase, is a form of a regional agreement where duties and other restrictive regulations of commerce are eliminated with respect to substantially all the trade between the constituent territories. Again, there can be some transition periods of up to 10 years. There can be there will be a need to provide a schedule if you do not eliminate it immediately. There are options, but for our current understanding, let's not go that deep in details. We understand that we need to eliminate duties and other restrictive regulations of commerce with respect to substantially all the trade between the constituent territories, so between the parties to a free trade area or a customs union. And again, I simplify because there is one more second phrase for the customs union. Let's leave it aside now. For our purposes, this is fine. How do we understand this phrase, substantially all the trade? So we understand when something is substantially all the trade, it's not all the trade. And we interpret legal text so that to give meaning to all the words used. So what is substantially all the trade? So we need to eliminate duties with respect to substantially all the trade. if we make a free trade area, can we still keep some duties? Or should we open up our borders completely to the products from our partner? That is exactly the question that is at stake when we interpret this provision. The appellate body in Turkey Textiles case tried to give some clarification. I would not consider this attempt very successful. It says, it is clear though that substantially all the trade is not the same as all the trade. Indeed. And also that substantially all the trade is something considerably more than merely some of the trade. That is it. So no more clarification, no more guidance. We are left to guess. Have this agreement liberalized with respect to substantially all the trade or not? Is it already substantially enough in scope or not? To what extent can we carve out products from free trade regime between two territories? We are left to guess. In the GATT 1994 practice, substantially all the trade has been interpreted actually in two dimensions, in the quantitative dimension and in the qualitative dimension. What does it actually mean? When I say two dimensions, quantity and quality, let's start with quantity. So there is a certain percentage of trade that shall be liberalized. And when I say liberalized, I mean duties shall not be applied to it, and other restrictive regulations of commerce shall also be eliminated. So how much freedom do we have in a free trade area to keep tariffs? There have been different proposals. Well, some claim it should be 95% of all HS tariff lines. There was a case called US line pipe, and in that case, for instance, NAFTA was analyzed, and it was said that NAFTA liberalizes 97% of mutual trade between the territories. It was considered sufficient. It was considered substantially all the trade. But what if we go to a much lower threshold? If we say 50%? Clearly not, insufficient. So seeking this balance is very difficult, and unfortunately, we will not find any dispute settlement report, any interpretation of WTO members that was made in the next 25 years from the moment GATT 1994 was adopted. And even since 1947, the text didn't change, and no clarity was added in 1994 at the end of the Uruguay round. So when we say what quantity is expected, we understand that it should be, well, a substantial portion of trade. More or less, there can be some sort of a consensus that it should be no less than 80% clearly. Because one of the arguments that were raised by the EU in their discussion in the Committee on Regional Trade Agreements about the EU Faroe Island Agreement is that about 50% of tariff lines account for 80% of trade. So if we try to deduct anything from these arguments, we may have the feeling that 80% is clearly the lowest threshold of trade liberalization. So you cannot clearly not go below 80. And then quality. If we talk of substantially all the trade test, we cannot exclude any major sector from the liberalization, from opening the borders. What do I mean by no major sector excluded? It all depends on the economy that we are actually considering. So each country has its own major sectors. They may not necessarily occupy a big share in the overall economy of the country, but they should be important sectors. Well, clearly in Russia, oil and gas are important sectors, no doubt. But somewhere in maybe, I don't know, Costa Rica, it may be less important. Though these materials are in most situations important sectors. Well, I could give you one clear example of a situation when the agreement called EFTA European Free Trade Agreement. It's Switzerland, Iceland, Liechtenstein, and Norway. After Free Trade Agreement, it at its outset actually excluded all agriculture from free trade. That was found to be contrary to the substantially all the trade test. So in order for you to have the right to give these preferences contrary to Article 1 MFN to your regional trading partner, you have to meet this requirement. You need to open up your markets significantly. Economically, we understand why it happens, because regional trade agreements cause trade diversion. To minimize trade diversion, the rule is open up your borders as much as possible. Open up your economy so that more products from your partner could enter it. And then maybe through this trade creation, we would minimize possible trade diversion. So that is one first criteria that necessarily has to be complied with so that you could actually utilize the exception under Article 1 for regional trade agreements, free trade areas, and customs unions. Article 24.5 has one more element that will have to be one second element, second part of the test we will have to comply with. The external requirement we discussed has to be met, and also the internal requirement has to be met. What is it about? It is also part of Article 25.5 in the GATT. It says, provided that it is not prohibited for you to give preferences under your free trade agreement and not give it to the rest of the world, despite MFN, provided that duties and other restrictive regulations of commerce imposed at the institution of such union in respect of trade with contracting parties not parties to such union shall not on the whole be higher or more restrictive than the general incidence of duties and regulations of commerce applicable prior to the formation of such union. If I were to translate it into the more common, simple language, what does it mean? It is the requirement that, actually, I think I mixed up the internal and the external on the slides. Actually, it's more of the external thing. Internal is the previous one. This one is the external, actually. Sorry for the confusion. This is clearly the external one. So it applies to other countries. And the idea is that you can do any agreement you wish. We are happy if you make free trade and if you open up your borders. It is positive. We are in favor of it. But as a result of that, other countries shall not suffer. If by any result, following your change in policy, following the formation of your customs union or free trade area, others suffer, such agreements cannot exist. So what is said here? Duties and other restrictive regulations of commerce with respect to other products from other countries before the union shall not be increased. So once you form the union, duties can either go down or remain at the same level. However, here it is important that the phrase says shall not on the whole be higher or more restrictive. Keep in mind that we make the calculations of both duties and other restrictive regulations of commerce. In order to explain this criterion in more detail, let me tell you about this case called Turkey Textiles. It is the situation when Turkey and EC decided to make a customs union. So what were the finding basic factual elements that had to be harmonized? Because you remember that a customs union implies harmonization of customs policies. They need now to act jointly and they need to decide jointly on the customs tariffs, all other non-tariff barriers, because there will be one common border with the rest of the world, and they won't have any border as amongst themselves. Customs border, again, maintaining all the political borders. So there were three important elements that we need to keep in mind. With respect to trade in textiles, clearly the case is with respect to trade in textiles. Turkey had a relatively high MFN tariff on textiles. It was 10% for textiles, 14% for clothing. In EU, tariffs were lower. It was 9% for both products. And moreover, in Turkey, there was the so-called mass housing fund levy. It was up to 20%. So in addition to those 10 or 14 foreign producers of fabrics, textiles, and clothing, when introducing those textiles to the territory of Turkey, will have to pay the effective duty of, say, 30 or 34%. So that is the situation when we see that the European market was much more open as compared to the Turkish market to foreign textiles. However, in those days, it was 1990s, there was an agreement which is no longer in force among Annex 1A agreements within the WTO system, agreement on textiles and clothing. And under those agreements, governments had a right to temporarily keep the quotas on textiles. As I said, that agreement now no longer functions. So those quotas do not exist these days, but there was a quota that EU had with respect to the importation of textiles. You remember that quotas are prohibited per se under Article 11 of the GATT. That is true. However, that was the exception, which we now even didn't talk about because these days it is no longer relevant. However, getting back to those times, Turkey has no quota on textiles and clothing, whereas EU does have a quota on textiles and clothing, which was permitted by the agreement on textiles and clothing. And again, think they are making a customs union. So they should develop some common policy with respect to both tariffs and quotas. So there are two options. Either they can accept the Turkish approach or the EU approach. It's option one. Option two, they can meet somewhere in the middle. But again, we don't know what are the international obligations of EU and Turkey in those days. And it may be the case that, for instance, tariff for textiles of 9% for EU was already the maximum possible applied rate, because 9% was bound by the schedule EU made as part of its tariff concessions. Even putting that aside, so let's assume they are not restricted in their schedules. They can do what they wish with respect to tariffs. Even if EU agrees to increase the tariffs, fine. Fine, if there is understanding, there will be no shortage in the domestic market. This is something we could live as long as it doesn't violate Article 2 of the GATT. However, as for the quota, what will they do with the quota? Because if Turkey does not actually implement any quota, does not restrict imports on textiles, then now all these textiles will start moving to the territory of the EU without any checks because they're coming from Turkey, and then it will be disastrous. So there will be no value in the European quota, right? Because as long as you don't control your borders, keeping your quota individually makes little sense. So what happened here? They actually did form the customs union. And what was the solution adopted? The solution adopted was as follows. Turkey accepted the European Common Tariff, EC, Common Customs Tariff. Turkey accepted it and it decreased its tariffs, MFN tariffs, on textiles. On the other hand, Turkey implemented a new quantitative restriction. So Turkey now introduces the quantitative restriction, which they never had before. But that is extended now to the whole market of the new customs union. And now imagine what happens. Who comes in? India. India comes in, and India is very unhappy with this new quota. Because before this formation of a customs union, India sent a lot of textiles to Turkey. Whereas now, India cannot send textiles to Turkey in the same amount because there is a quota. And once the quota is exhausted, you cannot do anything with it. We keep in mind that the quota itself is not illegitimate in this particular case, in these old days of 1990s. However, what India claims is that imports dropped dramatically from 1995, where there was no quota in Turkey. They received 42 point something million US dollars for their imports to Turkey. Imports in 1996, after the formation of the union, dropped twofold, and they even further dropped the year after. So India says, I'm very happy that you are such good friends, EC and Turkey. I'm happy for you, but I am not happy with the fact that my products are now suffering. They are facing the new border restriction, which they did not face actually before. So that is the core problem of the case. Can you really introduce such restrictions at the formation of the union, which will lead to some new barriers raised to other countries? But you cannot do it otherwise. Or the only way is then just to choose the most liberal of the two economies and follow its path. But even that is problematic. Countries may be very different in what they do and how they build up their trade policies. So when reading it once again in Article 24.5, let's try to understand again this requirement. It says, duties and other restrictive regulations of commerce imposed at the institution shall not be on the whole higher or more restrictive. What here matters are these words on the whole. Again, it implies some aggregate analysis. We do not only take into account the new matter that actually increased, that appeared in a market. We should keep in mind that tariffs decreased. So there should be some economic assessment performed. That is what panel in Turkey Textiles says. What paragraph 5a provides in short is that the effects of the resulting trade measure and policies of the new regional agreement shall not be more trade restrictive overall than were the constituent countries' previous trade policies, and that paragraph 5a provided for an economic test for assessing compatibility. So here the panel proposes a mechanism how to make this assessment. We need to make the overall aggregate analysis. We need to understand how much India actually gained because of the reduction of tariffs, and how much did India lose because of the introduction of a quota. And only through this economic test, only through these calculations, we will find out if actually this agreement is in compliance with the internal or external requirement, or it goes contrary to this external requirement. If it is permissible to give these preferences, or if they should be withdrawn as WTO incompatible. So what is one important thing here to bear in mind is that This assessment shall be made on the whole. It should be the aggregate analysis and not the analysis of just some individual new restriction that could come to existence. But actually, Turkey lost that case, but for the other reason. That is the reason why Turkey lost the case. In addition to that phrase which we were reading, see that Article 24.5 says that Article 1 shall not prevent the formation of a customs union, provided that. So here, in this same Turkey Textiles, appellate body gives one more idea on the interpretation of this provision. They say that, yes, you need to make sure that on the whole, barriers did not increase. But in addition to that, the party claiming that the benefit, well, let's just read the whole provision completely so that you see it. First, the party claiming the benefit of this defense from Article 1 and Article 24. From this defense must demonstrate that the measure at issue is introduced upon the formation of a customs union that fully meets the requirements of subparagraphs 8a and 5a. This is what we know. 8a is substantially all the trade test. 5a, also we know what we just discussed, that is prohibition to increase barriers on the whole, aggregate analysis. But this is just a first part of the element. Secondly, that party must demonstrate that the formation of the customs union would be prevented if it were not allowed to introduce the measure at issue. So that is the way they interpret the word shall not prevent the formation. And actually, here they say that there were other available alternatives Turkey could implement and the EC also could implement to prevent any possible diversion of trade, while at the same time meeting the requirements of subparagraph 8a. And they say, why didn't you introduce the certificate of origin system? Why didn't you introduce some mechanism of traceability of the product, of those textiles? So interestingly, this is actually the ultimate test for us to see if we can implement a regional trade agreement, if we can make a free trade area or a customs union with our partner, and if we can actually benefit from those advantages of non-MFN treatment. Those are the internal requirement, the external requirement, and the requirement that the formation of the free trade area or customs union would be otherwise prevented if certain restrictions were not introduced. So here are these three elements of test that we need to assess in order to make sure we can make a free trade area or a customs union WTO compatible. Once again, why do we spend that much time on that? We spend that much time on that because regional trade agreements are always necessarily violating Article 1. Article 1 says don't give preferences to products from one country, not giving these preferences to the other country. Free trade area, customs union, always gives preferences to one country and never extends those preferences immediately and unconditionally to the like products from other WTO members. So here, in order to make sure we can utilize this exception, we need to demonstrate that we comply with the definition, that internal requirement, so that substantially all the trade has been liberalized, the market has been opened substantially. Then we show that we comply with the external requirement 24.5, aggregate analysis, no new barriers raised on the whole. And then we need to demonstrate that the formation of the union would be preserved if we were not allowed to introduce the measure at issue. So every regional trade agreement within the system of, well, at least as amongst WTO members, has to be very carefully checked with respect to its compliance under Article 24. If the agreement does not comply with Article 24, then what happens? What are the legal consequences of that? Take a minute to think about it. So we think of the exception. We say that this is the exception from the general rule of MFN, or and maybe from the whole GATT. But for our purposes, it is sufficient to understand that Article 24 provides for an exception from the general MFN rule. If you do not qualify for the exception, it's just the general question of legal thinking. If you do not qualify for the exception to the rule, what will apply to you? The general rule. So those agreements which do not comply with these Article 24 requirements, and those are cumulative, all the three need to be established. So if they are not sufficiently open in coverage, if they have too many exceptions and exclusions, if they raise barriers with respect to the rest of the world, or if they just introduce some restrictions which did not actually preclude the formation of the customs union. What would happen with these agreements? The answer is nothing will happen with these agreements. Why so? They will remain legally valid. They do not become somehow unenforceable. They remain enforceable. But if your agreement does not comply with Article 24, then the general rule applies. General rule is Article 1. If you give preferences to the product from one territory, then you shall immediately and unconditionally grant the same preference, privilege, advantage to the like product from other WTO members. So what would be the real consequences of non-compliance with Article 24? If it is established by the WTO, for instance, by the Committee on Regional Trade Agreements that performs this work, if it is established that a regional trade agreement is not in compliance with Article 24, be it a free trade area or a customs union, then these preferences given to a regional trading partner, this zero tariff duty, shall be immediately and unconditionally extended to the rest of the WTO membership. So we will have to open up our markets to everyone, literally being WTO members. So if you want to use the benefits of these preferences under Article 24, then you have to comply with these requirements. If you do not comply, then give this same 0% under your free trade agreement to the rest of WTO members, or alternatively, before we actually decided, you can withdraw your regional agreement and or bring it in compliance with Article 24. So the last question with respect to Article 24 is whether it actually only applies to Article 1 as an exception, or it can also be used to justify some other WTO violations, some other GATT violations. So we will talk of Article 3, for instance. Well, and Article 2, could we say that we violate Article 2 because of the 24 exception? Actually, it is not an easy question to answer. Under Article 24.5 itself, it says that the provisions of this agreement shall not prevent the formation of the customs union or a free trade area. And when it says the provisions of this agreement, it seems that for some reason there is no reference only to Article 1. And the provisions of all GATT, therefore, could be sort of waived through Article 24.5. The panel in Turkey Textiles also arrives to a conclusion uh, that has been then challenged before the appellate body and successfully challenged. The panel arrives to a conclusion that it's only Article 1 violations, Article 1 deviations that can be justified through Article 24. The appellate body says it has no reasons to believe so, and it believes that some other provisions could be justified, but never clarifies which specifically. And then there was a case called Peru Agricultural Products, where the appellate body actually says that, in our view, references in paragraph 4 to facilitating trade and close integration are not consistent with the interpretation of Article 24 as a broad defense for measures in FTA that roll back on members' rights and obligations under the WTO covered agreements. The phrase is very difficult to understand, but here we again see some rollback, as they themselves say, that it is unlikely that Article 24 could be interpreted as a broad defense. But as for Article 1, you clearly can use Article 24 to go around Article 1. You clearly can give preferences to your regional trading partner in a free trade area, a customs union, a common market, doesn't matter, as long as you comply with those three elements we had on the previous slide. And then just a few words before I finish with regional integration. You remember the enabling clause. The enabling clause, which was the decision of the GATT contracting parties to foster the participation and fuller reciprocity of participation of developing countries in the global trade. And the enabling clause, in addition to permitting tariff preferences to developing countries, also provides for an alternative ground to make regional trade agreements, alternative to Article 24 actually, which is much less rigid and much less stringent in sense of those requirements imposed. Article 1 of the decision of the 28th November 1979, which we call in our bird language the enabling clause, says that nothing in the provisions of Article 1, and here you see there is only reference to Article 1 for whatever reason, but let's put it aside. Nothing in the provisions of Article 1 of the General Agreement disturbs, well, prohibits the contracting parties to accord differential and more favorable treatment to developing countries without according such treatment to other contracting parties. And then, reading further the enabling clause, we see what it says. The provisions of paragraph 1 apply to the following: regional or global arrangements entered amongst less developed contracting parties for the mutual reduction or elimination of tariffs in accordance with criteria conditions which may be prescribed by the contracting parties for the mutual reduction or elimination of non-tariff measures on products imported from one another. A little difficult to understand it immediately just reading it, so take some time, maybe put video on pause for a while, read it once again. But what is actually here at stake? Here we talk of some arrangements which could be made. It doesn't say agreements, but effectively we understand those would be some forms of international agreements amongst less developed contracting parties. And then what is the goal of those arrangements? Mutual reduction or elimination of tariffs, or mutual reduction or elimination of non-tariff measures on their products. It is particularly important to compare it to Article 24. You remember we said 24.8, duties and other restrictive regulations of commerce are eliminated, not reduced, are eliminated, meaning completely to zero. Here we say mutual reduction or elimination. So governments of developing countries can choose whether to reduce tariffs or eliminate them. They can choose whether to reduce or eliminate non-tariff measures. So they have much more freedom already from the wording that we identified. And then, as for the enabling clause, drawing up the conclusions from what we just read, it's the alternative ground for regional trade agreements amongst less developed contracting parties, so LDCs and developing. If we have any developed country that joins the picture, then the enabling clause is no longer available. That agreement will have to be set under Article 24 of the GATT and will have to comply to go contrary to Article 1, to violate Article 1. Then, most importantly, why do I focus on that? Within the enabling clause, take your time, read the document, read the whole of it. You will see that the test that is there is very vague. It is much more vague as compared to what we have in Article 24 with all those substantially all the trade, overall assessment, economic test. They are not there in the enabling clause. So making the agreements under the enabling clause is much simpler. You are not obliged to completely eliminate tariffs. You are not obliged to completely eliminate non-tariff barriers. You are not called to open up your markets substantially. You can still introduce some new barriers with respect to the rest of the world. It makes things much more complicated. And there were situations even when some countries like the Gulf Club countries, they first notified their free trade agreement under Article 24, then took some time to think about it, understood they all are developing countries, at least they claim to be developing countries, and they re-notified the agreement under the enabling clause, just to avoid this careful scrutiny and not to be found in violation of Article 24, which is much more rigid as compared to the enabling clause. So, do we have many notifications under the enabling clause? The answer is yes, relatively many. Out of 303, 61 notification is under the enabling clause. 61 out of 303. And one more thing that may be relevant, just keep it in mind somewhere in the very back, just for you to understand that there is even a different institutional division within the WTO responsible for enabling clause agreements, because they are more for the development purposes and not for regional trade integration purposes as we understand it. So these are the possible grounds for free trade agreements, free trade areas, customs unions, global arrangements for the reduction of tariffs, which are available. Article 24 and the enabling clause. Those both are exceptions from Article 1, and therefore you can necessarily, you have the right to go contrary to the principles set forth in Article 1 if you implement one of those measures. Preferences in sense of tariffs for the developing countries, GSP, this is what we discussed in the previous lecture, and regional integration. Those are free trade areas, customs unions that are subject to disciplines of Article 24 and the enabling clause. So as for the key MFN exceptions, let me sum it up. MFN is the basic fundamental obligation that has to be complied with, and you cannot discriminate products based on their origin, but there are exceptions which permit that to happen. Exceptions in Article 1.2 we discussed, mostly outdated. Exceptions in the articles of the enabling clause permit flexibilities to the developing countries when you can go against Article 1. And now one more, and the last actually of the institutional fundamental exceptions from MFN, it's GATT Article 24, regional trade agreements, free trade areas, and customs unions. Yes, you can violate MFN, but you have to comply with those requirements which we talked about those internal, external requirement, and the phrase that otherwise the formation of a customs union or a free trade area would be precluded if the restrictions that may be implemented, new restrictions implemented, were not in place. Actually, MFN is so fundamental that you will not only find it in the GATT agreement, but it will also be there in the GATS agreement and in the TRIPS agreement. In the GATS agreement, there are also similar flexibilities available to the arrangements like free trade areas or customs unions. It is called economic integration agreements. So for services, such exceptions like Article 24 are also possible. It's Article 5 of the GATT. Just keep in mind that for services, it also exists. For the TRIPS agreement, this is also the most fundamental obligation. We do not have that regional component there available as a justification of any policies that will be discriminatory under the TRIPS agreement for intellectual property protection. But all this is just to emphasize that MFN is so fundamental, it is so important that with all possible intellectual property, goods or services, discrimination of products based on origin is not permitted. There are very few exceptions which can be implemented. They are rather strict in sense of rules, how they work and how they could apply. And those rules, unless strictly complied with, will not permit you violate MFN. And then, if that happens, if you don't comply with the exception, then the general rule would apply. And what happens is that any advantage, favor, privilege, immunity that will be granted to any product originating in any country shall be immediately and unconditionally granted to the like domestic product from all other WTO members. So that is it with respect to MFN, and we now switch to the discussion of the second major non-discrimination provision, second major principle of international economic law, that is national treatment, Article 3.